Get everybody back in here?
I don't know if we're going to get everybody back in here.
Yeah. We do, okay.
You have a noisemaker?
Don,
Well,
on your intro, I wanted to use the points that you said, but I don't want to leave the computer open, so I picked out some to put here. Is that okay? I made my own intro for you.
Yeah.
Is that okay?
yeah, that's fine.
Yeah.
Keep it short.
Okay. I should have brought my
What?
some munchies from out there too. No,
Where's four?
It's all right.
Pretzels make it hard to talk, though.
Yeah, that's what I was supposed to have.
The cheese ain't going to be so much better.
Things be hanging.
Hey, are you going back tonight, or are you staying?
Tomorrow.
Does Noah know how to
I'm going out from. I'm bringing a bunch of people to
Noah?
I don't really care.
party after if you're interested later.
It doesn't bother me if people mispronounce
Show and
it.
stuff. This mainstream is downtown Durham, but
I was really touched by this. But, you know, it's
Pronounce your
last
last name
show
wrong.
at the
Yeah.
at a
Yeah, you're very
like
close.
performance
You're-
bar, more like art.
Yeah.
arts
We
thing.
have everybody from outside.
I'd like to see that.
Okay.
I'd love if you could come.
Oh, that's true. They can hear. Ooh.
I knew he was going to do that.
Okay, we're going to get started with our final panel. Our final panel is on the crime of aggression and the complementarity principle. And I'm going to yield the floor quickly because obviously you guys aren't here to see me. So I'm going to give the floor to our moderator, Professor Noah Weisbord, who most you guys have all already met before, and Professor Weisbord.
Thank you very much, Drew. I congratulate you all for making it to the last panel of the day. And it's been a very dense day. You should all get a diploma on the crime of aggression when you leave because you've sat through until the end. It's been rich, and I hope that you are not concerned that you missed something, because all of this stuff will be available for you to follow up on if you need to read Robbie's article or Astrid's or any of ours. We've often written on the subject that we're speaking about. So don't be worried if you're missing specific details, or somebody can explain also to you. You have a general basis now. This last panel is on quite, it's a much more practical, less legally intricate issue than the last one that we handled. The last one that we addressed was extremely important, but now what we're going to address is the idea of whether national jurisdictions, whether and how national jurisdictions might have the power to try political and military leaders for the crime of aggression. So imagine that it's not the ICC that's doing the trial, but it's a criminal court in Canada, in one of the African states that has signed up to the ICC statute, or some other place. Who could be tried, under what situations? Because just a reminder that the system of complementarity of the Rome Statute means that the ICC is, in essence, a court of last resort. It's up to, first and foremost, the states to prosecute crimes within their jurisdiction, genocide, crimes against humanity, and aggression within their jurisdiction. And then if the court is unwilling or unable to proceed, if the national jurisdiction is unable or unwilling to proceed, then the ICC steps in. So this is the problem that we're addressing today. So I will introduce the speakers right before each one speaks, and I've made short introductions. We're starting with Don Ferencz. Don's an attorney and the executive director of the Planethood Foundation. He holds both a JD and an MBA. His foundation educates to replace the law of force with the force of law. Don pursued a commercial career for over 2 decades and also worked as an elementary school teacher. His mind is sharp and lively, and I'm delighted that you're going to get a taste of that today. Don was an important participant in the official and the unofficial negotiations over the crime of aggression. He attended every meeting of the Special Working Group on the Crime of Aggression and a lot of the outside meetings, so he has a wealth of knowledge about what went on in the process. And he recently created the Global Institute for the Prevention of Aggression. I introduce Don Ferencz.
Thanks very much, Noah, for that overly generous introduction. After Robbie Manson, I don't think any of us are going to appear particularly sharp and quick, but I really enjoyed Robbie's presentation, and in fact, Robbie's one of the people I've been in discussion with for quite a number of years on some of these topics. I want to comment immediately on something that Noah just said, but before I do, I want to just say a couple of words about what it is that I would like to do. And I've got a number of papers here that I want to touch on. I'm going to be a little bit like the person who comes out before the meal with a little tray of hors d'oeuvres and the canapes. I have a number of little taster things that I want to just talk about, and then I'll leave it to Michael, Professor Scharf, and Professor Wrange to talk a little bit more in depth about some specifics. But before I do any of that, I've been asked to do a public service announcement. One of the people invited to come to this symposium who couldn't make it was my father, Benjamin Ferencz, who is known to many of you as a former Nuremberg prosecutor. I myself was born in Nuremberg because he stayed on after the war. And he's asked me to just share a few points. I'm not going to read all of his comments, but he wants me to say, on his behalf to all present, that the ICC statute should be adopted and ratified and brought into national jurisdictions as quickly as possible, that he believes that illegal war is also a crime against humanity, and that the use of force in contravention of the UN Charter constitutes a manifest and flagrant breach of the Universal Declaration of Human Rights, which proclaims, quote, everyone has the right to life, liberty, and security of person. And those are his comments that I wanted to very, very quickly share with you. In addition to his comments, as some of you may be aware, the Office of the High Commissioner of Human Rights has been looking into the question of whether the right to peace is a basic human right. So that's one little thing I wanted to share with you. And I also wanted to share a very quick personal observation relative to, for example, the toasts that have been proposed last night to Stefan Barriga for the incredible job that he and his colleagues did, in particular Ambassador Christian Beneveser and Prince Zaid. And I brought some show and tell, just to give you some idea of how unlikely some thought it was that anything was going to be achieved in Kampala on aggression. And I'll read just the headline. I know you can't all read it from where you are. This is the local Kampala newspaper that opened with a massive headline on June 6th, ICC fails to agree on aggression. Some of us thought the notice of sort of demise was a little bit premature. So I wanted to share those little things with you. I'll put this down here so it doesn't fall down. And I want to get in immediately to a comment that Noah made, and it's not scripted. I didn't ask him to say this. But in preparing to talk a little bit about our topic, which is not simply the question of national jurisdictions and national legislation, but the question of complementarity. And when I think of complementarity, I ask myself the question, well, who and what is complementary to who and what? It is the ICC that is in fact complementary to national jurisdictions and not the opposite of that. So when I think of complementarity, I think of both pieces of the equation. How and when can the International Criminal Court complement national jurisdictions? So we look at both of them together. And in this regard, of course, the word complementarity is not one that appears in the statute itself. The preamble talks about the complementary principle, and you see it referenced in Article 17. There is an article that was among those that I looked at in preparation for talking with you today that I came upon called The Mysteriousness of Complementarity. And this is written by a Canadian professor, and I think he has also diplomatic involvement, Darrell Robinson, and he touches on those who use the exact phrasing that Professor Weisbord used in terms of, if you will, defining the ICC role as saying that the ICC can get involved when state national courts are unwilling or unable to try a case. And he has picked up on this language because he says that, in fact, that's not the right way to think about complementarity principle. He thinks of it more broadly. If you look at inadmissibility, what you see in the statute is that a prosecutor must go and find out if a national jurisdiction is investigating a case before the ICC can generally take jurisdiction. But the statute says that a case will be inadmissible before the ICC if it is being investigated in a national jurisdiction, unless that is a sham type of an investigation or prosecution. So I just wanted to make the point on behalf of Darrell Robinson and the mysteriousness of complementarity, that in fact it ought to be thought of a little bit more broadly. The court, in fact, can take jurisdiction over a case, and it's not necessarily, if you will, reliant per se, although we do tend to think in terms of it proceeding after the primacy of a national jurisdiction is already, how shall we say, exhausted. So, okay, so I've done that now. I can lighten my load.
Onto my space here on the table.
Now,
Thank you.
now, a couple of other things. I want to comment on something which is such an arcane point that has been discussed in the previous panel, but it comes up because we're here today in this panel to talk about what happened in Kampala relative to the complementarity principle. Unrelated to complementarity, I'll just tell you very quickly that while I was in Kampala, I was asked by the American Society of International Law to post something on their blog refuting something that had previously been posted saying that the review conference should do nothing at all on aggression. And I did. And what I wrote was, among other things, in if you will, advocating for the court, the ASP to do something, was that if all they did was allow the Security Council exclusive jurisdiction over the crime, that when it came time to take the roll call on this question, that in addition to headsets for translations, that I thought perhaps some might feel that nose clips ought to also be provided, because many felt that that would have been so unfair and so unjust. Now, when I wrote my little bit for the American Society of International Law, I didn't know that in fact there was going to be a provision, which I'm going to read to you, you've heard it talked about in the last session, that says, in respect of a state that is not a party to this statute, the court shall not exercise its jurisdiction over the crime of aggression when committed by that state's nationals or on its territory, period. Now, Article 12 of the Rome Statute allows for non-state parties with respect to the other three crimes to grant the court jurisdiction by way of a special declaration. And this is what was discussed somewhat in the last panel. Now, the fact that this specific provision does not allow for non-state parties to come before the court at their discretion and allow the court to take jurisdiction over them is very different than the way the Rome Statute works with respect to the other three core crimes. When I first saw this circulated, I thought, this is an oversight. It's a mistake. I was sitting next to David Sheffer, who was the ambassador at large for war crimes under the Clinton administration, and I drafted right there on the spot the following words. I added in handwriting, unless such state shall have lodged a declaration with the registrar accepting the court's exercise of jurisdiction over the crime of aggression in accordance with Article 12, paragraph 3. And I mention this for a very specific reason. Robbie Manson correctly said that you don't really even get to the question of statutory interpretation unless there is some ambiguity, and when you have to look into the legislative intent, you analyze, all of the, if you will, available facts and documents. I know for a fact because I took a piece of paper with this language on it and immediately handed it to Stefan Barriga during the ongoing conference at the ASP. And when I saw the next draft come back, I realized this was no oversight, that this provision was not being written into the statute. So I know, as a matter of my own experience, that the legislative history proves really that this was not an oversight, and I was interested that even in Stefan's recollection of it, he perhaps doesn't remember that somebody was trying to push the envelope on this with him. So it's a small point, but it goes, Robbie, to the issue that you were raising as to whether or not this may or may not be something that non-states parties yet can do. And I think of it in the context of complementarity, because the court, in being able to exercise jurisdiction, is complementing national jurisdictions. There is no prohibition, of course, on a non-state party enacting its own enabling legislation at the national level to prosecute people for the crime of aggression. And I'm going to let Michael and Paul all talk more about that subject. So I just wanted to kind of wet your whistle a little bit on this one. As a very small matter, I would add that something else happened in Kampala. It's sort of a picayune thing. There are provisions in the Rome Statute relative to the question of who can be tried by whom for what, national courts versus ICC, which go to, of course, questions of gravity. A case may not necessarily be admissible if it's not sufficiently grave, but there are also questions of double jeopardy. That is to say that the court may or may not be able to hear a case, depending upon whether the individual has been tried for conduct at the local level, which constitutes the same type of conduct included in the crimes before the ICC, and vice versa. A state may not be able to prosecute in the national courts persons for crimes for which they have been tried at the level of the ICC. And interestingly, one of the small corrections, really, that was made in Kampala, and you see it in the amendments, was a smoothing out of something that was actually, I think, incorrect in the Rome Statute as drafted. There's a provision relative to double jeopardy that doesn't specify that the crime of aggression would be covered, but talks about crimes falling within Article 6, 7, and 8 as it was then drafted. Now we have it clarified that in terms of double jeopardy, it does also cover the crime of aggression. If somebody is tried for aggression at the state level, the ICC cannot try the person. So that was a small correction on the question of double jeopardy. I don't really need to say, I don't think, too much more, but I want to bring something to your attention because Mike Scharf and I talked about the fact that he is going to touch on a question of whether, if national jurisdictions take charge over the crime of aggression, whether it would be on the basis of universal jurisdiction. And when he and I were talking about it, I brought to his attention something that I'd also seen in preparation for this meeting. Some of you may be aware that there is a bill, 1346, called, in the U.S., called Crimes Against Humanity Act of 2010 that was introduced recently. And without going into all the details, I will tell you that the first draft of this bill effectively granted universal jurisdiction over this crime so that parties didn't have to have a nexus with the United States. And the second draft is more narrow. It effectively excludes the principle of universal jurisdiction from being applied. So I mention that it's not the crime of aggression, but it is one of the other core crimes. I may think of a few other things to say from my seat, but I wanted just to get us moving because time is short, and I'd like to turn it over to our other
Thanks
panelists.
very much, Don.
Okay.
Our next speaker, Professor Paul Wrange, Associate Professor of Public International Law. Oh, sorry, we're going to go with other order. Professor Michael Scharf, I would say one of America's most renowned international criminal law scholars, a graduate of Duke Law School, and the school is very proud to count him among its alumni. Michael is a professor at Case Western Reserve University School of Law, and he's the director of the Frederick Cox International Law Center. He served in the Office of the Legal Advisor of the U.S. Department of State during the first Bush and Clinton administrations. In February 2005, Professor Scharf and the organization he founded, the Public International Law and Policy Group, were nominated for the Nobel Peace Prize. Professor Scharf.
Thank you.
Well, let me thank Noah, first of all, for that introduction, and also for joining me and keeping me safe on the Level 6 rapids at Zinja, which we did during the weekend of the Kampala conference while so many of the government people were working around the clock. I also want to thank the student organizers and the sponsors for including me. It is, as a double Dookie. I was a Duke undergrad and JD. It is always so great to be back here. And I'm so impressed with how the international law program here has grown in the 25 years since when I was a 1L. I came in and they didn't have an international law society, and so Robbie Robertson and I, who was the professor of international law, put it together, and then he helped me co-found the Duke Journal of International Law, which has done so well over these years. Complementarity for the other core crimes in the ICC statute is bolstered by the fact that those are crimes of universal jurisdiction. And as Don noted, many states that have ratified the Rome Statute have added universal jurisdiction to their implementing legislation. Now, in recent years, the United States itself has enacted statutes providing universal jurisdiction for some of those core crimes, for torture, for war crimes, and one version of the pending legislation, the Durbin Bill, also would put it for crimes against humanity. My remarks today will focus on whether the crime of aggression is a crime subject to universal jurisdiction under customary international law, such that it would be legitimate for countries to enact domestic legislation giving them not just nationality-based jurisdiction and territorial-based jurisdiction, but also universal jurisdiction to prosecute those accused of waging a war of aggression. To answer that question, I'm going to have to take you back 65 years in time to the period when Ben Ferencz looked even younger than his son Don, and we're back at the Nuremberg Tribunal. And the question I want to address is, was Nuremberg an international court applying universal jurisdiction over international crimes? Or was it a court of occupying powers applying territorial jurisdiction? There are, in fact, two strands of thought on this, and there's a third strand where people just say it's unclear and it doesn't matter. You don't have to decide. My thesis is that there is enough evidence that it is the former, and that countries are going to use that evidence, and they will, in fact, start to implement the crime of aggression domestically using universal jurisdiction. To prove this point, I want to rely on 7 different pieces of evidence. First of all, in his seminal 1946 article on the Nuremberg Tribunal, Professor Egon Schwelb listed the following features which he believed evidenced that Nuremberg was not a mere occupation court applying national law, but rather an international judicial body applying universal jurisdiction. First was the name given to the court, the International Military Tribunal. Second was the reference in the preamble of the Nuremberg Tribunal Charter to the fact that the 4 signatories are, quote, acting in the interests of all the United Nations. Third was the provision in Article 5 of that charter giving any government of the United Nations the right to become a party to the agreement. And the Nuremberg Charter was not only signed by the 4 great powers, but it had many other countries that ratified it as well. And finally, the provision of Article 6, according to which the jurisdiction of the Nuremberg Tribunal is not restricted to German perpetrators, although that's all it ended up prosecuting. The actual jurisdiction was broad enough to cover all European Axis country perpetrators, even those outside the occupying powers' jurisdiction and control as occupiers. The second piece of evidence. The Nuremberg judgment itself contains 3 passages that indicate that the court was exercising universal jurisdiction. One quote, "In establishing this tribunal, the signatory powers have done together what any one of them might have done singly." Secondly, quote, "The tribunal has jurisdiction to punish crimes against international law." And thirdly, quote, "The very essence of the charter is that individuals have international duties which transcend the national obligations of obedience imposed by the individual state." Now third, let's look at the opening statements of the US prosecutor Robert Jackson and the UK prosecutor Sir Hartley Shawcross, which both drew an analogy between the right to prosecute pirates under universal jurisdiction and the legitimacy of the Nuremberg Tribunal's exercise of jurisdiction over war crimes, crimes against humanity, and the crime of aggression. Jackson, in his opening statement, also said, quote, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from the other crimes in that it contains within itself the accumulated evil of the whole." Fourth piece of evidence. The definitive report of the United Nations Secretary General describing what the precedent of Nuremberg was all about and submitted to the United Nations in 1949 concludes with this statement, quote, "The court considered the crimes under the Nuremberg Charter to be as international crimes subject to the jurisdiction of every state. The case of piracy would then be the appropriate parallel." And of course, everybody knows that piracy was the definitive and initial crime of universal jurisdiction. Fifth piece of evidence. The Control Council Law Number 10 trials, which were based on the Nuremberg Charter and its precedent, referred to their jurisdiction under the principle of universal jurisdiction in the judgments of the Hadamar trial, the Zyklon B case, and the Eisengruppen case. And sixth piece of evidence. The U.S. Court of Appeals for the Sixth Circuit stated in the Demjanjuk case, when it was sending this former prison camp guard to Israel to be prosecuted under Israel's assertion of universal jurisdiction, quote, "It is generally agreed that the establishment of the Nuremberg and Control Council Law Number 10 tribunals and their proceedings were based on universal jurisdiction," end quote. And finally, seventh, the report of the UN Committee of Experts, chaired by Sharif Bassioni and former Yugoslavia, which in part led to the establishment of what was, in essence, the first international tribunal in 50 years since Nuremberg, concluded, quote, "States may choose to combine their jurisdiction under the universality principle and vest this combined jurisdiction in an international tribunal." The quote continues, "The Nuremberg International Military Tribunal may be said to have derived its jurisdiction from such a combination of national jurisdiction of the state parties to the Nuremberg Charter." So what is the relevance of all of this? Well, if you open up the handout, Annex 3, with the understandings, you'll see that one of the understandings adopted in Kampala provides, quote, "It is understood that the amendments shall not be interpreted as creating the right or obligation to exercise domestic jurisdiction with respect to an act of aggression commissioned by another state." They are trying to make sure that the new amendment does not create new customary international law. But guess what? 65 years ago, that deed was already done. On June 16th, at the American Society of International Law panel, Todd's boss, Harold Coe, and Stephen Rapp basically described for the world the American position of what they felt about what occurred in Kampala. They said, quote, "The outcome of the Kampala conference served U.S. interests." They said also, quote, "While the U.S. didn't achieve its goal of exclusive Security Council trigger, the chances of a prosecution of U.S. officials is zero, and the chances of a chilling effect is very low." Not sure that that's the case. I predict that notwithstanding the understanding, notwithstanding the very optimistic phraseology of Messrs. Coe and Rapp, that many countries are in fact going to do what Russia has already done, which is to enact domestic laws authorizing their courts to prosecute aggression. And when they do so, many of them are going to say, wow, what we're trying to do is be consistent. This is an ICC amendment. Let's be consistent with how we're treating the other core crimes. Let's have universal jurisdiction. Now, Robbie has already said he's going to go back and try to convince Scotland to do that very thing. And I believe you'll probably succeed. Astrid said Bosnia and the two entities in Bosnia have done that very thing. And I think we're going to see a lot of countries doing so as well, for symbolic reasons, maybe more than actual reasons. But what that means is that the unintended consequence of Kampala may in fact be an increase in civil and criminal litigation against maybe former U.S. officials for things like the 1999 intervention against Serbia, which people are still debating. Was that a crime of aggression, or was that not a manifest crime of aggression? Things like the 2003 invasion of Iraq, still under debate. Or, and maybe more concerning to people that are thinking in the future, any future preemptive attack against Iran to prevent it from deploying any nuclear weapons. Well, we can debate whether any of this would be a positive or negative development. But what my purpose today in bringing it to your attention is to make sure that academics and people in the government begin to give this some very serious thought. Thank you.
Thank you, Michael. I hope you're all getting a chance to see how revolutionary this subject is about complementarity and the crime of aggression and the widespread implications. Our next speaker, Paul Wrange, Associate Professor of Public International Law at Stockholm University, who is the former Principal Legal Advisor at the Swedish Ministry of Foreign Affairs. Paul Wrange was former political advisor to the EU's Special Representative for the Great Lakes in Africa. He represented Sweden at the negotiations over the ICC from early on and also in Kampala. Paul Wrange's scholarship is permeated by his dry sense of humor, his incisive gaze, and his short sentences.
I don't know where I got that from. Okay, thank you very much. And let me first thank the hosts and the organizers, the law school and the ICC student network for a very warm hospitality. I would say warm and enthusiastic hospitality and a great event. Now, in Kampala, to the disbelief of many of us, it's been said already, a miracle occurred and provisions on the crime of aggression were adopted. What will that mean for domestic jurisdictions? I will divide these brief remarks, which I think will, by and large, be in agreement with Michael Scharf's remarks. I will divide them into two parts. First, I will address some, but far from all of the challenges that might surround the implementation of the crime of aggression in domestic legal systems. Secondly, I will ask from a legal policy perspective whether such implementation will be a good thing or not, and if it's not a completely good thing, what could possibly be done about it. Okay, the first part. The first set of questions concern if the crime of aggression may or even should be implemented in domestic law. This covers the status of the crime under international law, its definition, whether domestic institutions have jurisdiction over it. It involves the principle of legality, relevant for the individual, as well as the principle of non-interference, which comes into play when one country overstretches or may overstretch its jurisdiction to interfere in the internal affairs of other states. Now, it is fairly clear that the crime of aggression is already an international crime that, in principle at least, may be prosecuted in domestic jurisdictions. It is one of the 4 crimes in Article 5, and the preamble of the Rome Statute states that it is the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes. End of quote. And this view, of course, was corroborated by the House of Lords in the case R versus Jones, which our friend Bill Manson is intimately familiar with. And it's further confirmed in some form or another by around 30 or so provisions on aggression or similar crimes in domestic statutes. And the most famous one, as was alluded to by Professor Scharf, is Article 353 in the Russian Criminal Code. However, a different question is whether the particular definition adopted in Kampala corresponds to international customary law, and if that definition is otherwise appropriate for domestic law. After all, it was drafted for the purpose of the Rome Statute. One of the so-called understandings which were adopted in Rome as a part of the deal says, "It is understood that the amendments that address the definition of the act of aggression and the crime of aggression do so for the purpose of this statute only. The amendments shall, in accordance with Article 10 of the Rome Statute, not be interpreted as limiting or prejudicing in any way existing or developing rules of international law for purposes other than this statute." So, technically speaking, it is not necessarily the case that the definition adopted in Kampala is the customary international law definition. But I believe that for all practical purposes, the vast majority of governments will indeed take it that it is that definition, which corresponds to customary international law, since almost all of the other criminal provisions in the statute do correspond to customary international law. For sure, state practice is quite scant in this area, but states will look at the quite well-documented opinion juris from the long and laborious and detailed discussions in the various formats of the special working group. And if that is not sufficient for a very conservative country, one could safely opt or proceed from the more restricted Nuremberg precedent. So the definition is an issue, but it's not an obstacle, I would say. A slightly more thorny issue is that of jurisdiction. Another Kampala understanding provides that, quote, the amendments shall not be interpreted as creating the right or obligation to exercise domestic jurisdiction with respect to an act of aggression committed by another state. Now, as is well known, international law recognizes several possible grounds for criminal jurisdiction: territoriality, the nationality of the perpetrator or the victim, national security, and the universal interest. Now, jurisdiction on the basis of active nationality principle and the territorial principle are absolutely uncontroversial, and I submit that includes cases where the relevant conduct, such as an order to attack, took place on the territory of a foreign state if the effects of that conduct reached the foreign state. So, if the foreign state is the victim state. Now, the interesting question is if domestic courts can go further, or if domestic jurisdictions can go further. In the 1996 draft Code of Crimes against the Peace and Security of Mankind, which was kind of the starting point, the documents from which the ICC negotiations proceeded. In that code, the International Law Commission proposed that only the ICC and the aggressor state should have jurisdiction over the crime of aggression. And that seems to be a very restricted view. However, this draft does not build on existing state practice, except for a very general invocation of the principle parem parem imperium non habet. The commentary only refers to what the Commission finds proper and practical, rather than to state practice. In fact, it was referring to what some particular members from some particular countries of the Commission thought proper and practical. So, contrary to that view, after World War II, a number of allied countries did adopt laws specifically for the prosecution of the recent aggressors, that is, for people from other states. And a couple also did pursue such prosecutions. Now, more controversially, or slightly more controversial, I was impressed by Michael's presentation, so so perhaps it's not as controversial as I thought, but it is. Some people will surely think it is controversial still, even after Michael's forceful argument. And also potentially more disturbing for international relations is universal jurisdiction. Now, many commentators believe that universal jurisdiction does apply to the crime of aggression, and others would be more cautious and point to the lack of positive, and I emphasize positive, state practice after the post-World War II years. Now, I believe that, at least partly, this question hinges on whether one accepts the old Lotus principle from 1927. If so, the relevant question is not if there is customary law support for such jurisdiction, but rather if there is a customary law prohibition of such jurisdiction. And I think not. So my slightly educated guess is that states may go ahead and introduce universal jurisdiction. At any rate, even if a state may extend its jurisdiction over the crime of aggression, I think there's very likely no duty to do so. So there's still a span of possible choices for states here. So it appears that the possibilities for implementing the crime of aggression and assuming broad jurisdiction are fairly good for states that want to do that. For sure, there will be practical issues, like the difficulties in gathering evidence in a foreign state. And there will also be legal problems related to the complementarity principle and the relation between the crime of aggression and domestic crimes that a suspect may be prosecuted under. But there's no time to deal with those rather technical issues here. Instead, I will mention a couple of issues that have to do more directly with the political sensitivities of the crime. The crime of aggression is a leadership crime, and therefore in domestic prosecutions in foreign courts, immunity will be invoked. Immunities generally come under two rubrics, and I'm here referring to the Princeton principles: substantive or functional immunity and procedure or personal immunity, as they were called in this set of codifying principles. The first type of immunity means that officers of a state shall not be liable for state acts. It's the state that is responsible, not the individuals. As in the Pinochet case, courts will probably not feel that this applies to international crimes. So international crimes constitute an exception to this principle. Therefore, in case of an aggression, foreign officials can only rely on the second type of immunity, procedural immunity. This entails that some types of officials are immune as long as they hold a certain office. For instance, that of a foreign minister, a head of state, or a posted diplomat. This type of immunity will normally prevent the state from prosecuting, even for international crimes. And this was upheld by the World Court in the arrest warrant case in 2002. So in distinction to what is the case before the ICC, in national jurisdictions, procedural immunity trumps any right of a state to prosecute international crimes. So suspects of aggression may, in many cases, be protected by immunities. However, even so, a prosecution will have effects. A potential suspect may not know whether the local authorities in a given foreign country will or will not accept that procedural immunity shields her, and may therefore refrain from traveling. This will affect the ability of a leader to function, as well as his or her legitimacy. Further, an incumbent leader will fear that procedural immunities will not protect, or will know that procedural immunities will not protect her when she leaves office. Now, in addition, there are also other what I call avoidance techniques, like the act of state doctrine and the political questions doctrine, which come under various names, but I will not refer any further to them here because they are not determined by international law. They are provided by committee, and they only apply in certain jurisdictions. But another technique with a similar purpose is for states to introduce legislation that requires an authorization from the executive before a proceeding against a foreign national for international crimes takes place. That is another way of avoiding politically sensitive prosecutions. Now, so states can safely use the Kampala definition of the crime. They could probably extend jurisdiction to universal jurisdiction, and they will likely apply at least procedural immunities, but probably not substantive immunities. So that sums up the first and the longest part of my presentation. So let me now turn to the second and considerably shorter, Mr. Chair, part. Will the world be a better one if the crime of aggression is being implemented in national jurisdictions? Let me first say now that it's, of course, never possible to fully predict the social consequences of legislation, and in particular, is this true of international legislation. As for any type of legislation, the domestication of the crime of aggression will have some good consequences and some bad ones. We can never completely avoid bad consequences. The issue is what the balance will be. So, what are the pros and cons, or the advantages and the negative effects? Well, first of all, prosecutions of aggression will probably make international relations more difficult, in particular when states charge or try to charge sitting officials of a foreign state under universal jurisdiction. Now, it is often held that the crime of aggression is the most controversial and politically charged crime, but is that so unique for aggression? So is it true, for instance, that the case between Serbia and Bosnia, which was adjudicated in 2007, which concerns the crime of genocide, was that less controversial than the case between, say, Congo and Uganda, which was adjudicated just a little bit more than a year earlier? So hasn't the word genocide been used lately with even more political and emotional force than aggression? Further, aggression is committed only by states, at least according to the definition adopted in Kampala. That is also often held to be something that distinguishes aggression from the other crimes. But is that also so unique for aggression? Most acts of genocide that have been committed or have allegedly been committed in recent years have a clear state nexus, like Rwanda and, for sure, Darfur. Now, secondly, the criminalization will contribute to strengthen the prohibition of the use of force, even if it might not actually be prosecuted very often. For sure, potential culprits of war crimes in a civil war, in a murky situation where such people might not be so concerned about the Rome Statute and a faraway court in The Hague. But leaders that contemplate aggression, they will be acutely aware of that risk and of other risks of prosecutions. Hence, I believe all other things equal, increased criminalization in domestic jurisdictions will deter the use of force, at least to some extent. And for sure, some people will think that that limitation of the freedom of action is something negative. But I would like to point at one specific issue here, and that also alludes to Professor Scharf's presentation. Because it may deter some violent behavior that a lot of us actually endorse, namely military interventions for humanitarian purposes. And it was for precisely this reason that many of us, for many years, and in the end successfully pressed for the word manifest to be retained in the definition. In Kampala, the US delegation ambitiously, and I think helpfully, proposed in the understanding that for the purpose of the statute, an act cannot be considered to be a manifest violation of the UN Charter unless it would be objectively evident to any state conducting itself in the matter in accordance with normal practice and in good faith, and thus an act undertaken in connection with an effort to prevent, and here it comes, to prevent the commission of any of the crimes contained in Article 6, 7, or 8 of the statute would not constitute an act of aggression. So, actions to prevent genocide, crimes against humanity, and war crimes would not constitute aggression. Now, I believe personally that that formulation was a bit too broad, but I think it captures something that we would like to see prevail. But for reasons I think quite obvious for anyone who is vaguely familiar with international politics, that formulation had no chances to fly. Now, I will come back to that soon, because I will now end with a brief summary and two brief policy recommendations. So here's the summary. It is likely that many states will domesticate the crime of aggression as they ratify the new provisions of the Rome Statute. I agree with Michael. And they will most likely proceed from the definition adopted. Some states may be more cautious about extending jurisdiction beyond territoriality and active nationality principles, and they may be a bit cautious, perhaps not for legal reasons, but for policy reasons. The two recommendations are the following. Now, in order to somewhat limit the risk for wild domestic prosecutions of the crime of aggression, states should ratify and allow the court to proceed and create guiding precedents. And I think that is quite important for this crime, which does not benefit from the kind of rich practice that we have for the other three crimes, and in particular for war crimes. The second recommendation, when states ratify the new provisions, they should make interpretative declarations to the effect that the word manifest means that use of military force to save civilian populations from widespread atrocities is not manifestly illegal if conducted according to the other general principles on the use of force, necessity, proportionality, and so forth. So I think that this would strengthen the meaning of the word manifest, which is admittedly vague, although it's not vague to the it's not completely devoid of content, but it could be filled with content if states make such declarations. So, Noah, I hope I have kept my time limit, and I thank you for your attention and look forward to any questions you might have. Thanks.
Thank you very much, Paul. I'd like to refer you to Paul's article on complementarity and the crime of aggression, which is either out or about to come out, and you can find some of his arguments that he just made in there. Now, I don't want to pass over the commentators. It's important that you get in here, but I'm afraid that the audience didn't get a chance to participate for the last panel. So I would like to start off with short questions from the audience, and preferably pithy answers by the panelists. And we're gonna do maybe 2 or 3 questions if they're short. Please just limit yourself to one, and we're going to try to have a pithy exchange between the audience and the panelists, please, and I'm going to move it along if it gets too sluggish. So, Casey.
I have a question specifically for Professor Scharf. I was wondering why you thought that there's potential for the U.S. to be subjected to prosecutions for the crime of aggression based on domestic statutes for universal jurisdiction. And I was thinking specifically of the case of Belgium, which formerly had a very broad universal jurisdiction statute, allowing it to prosecute several people involved in the Rwandan genocide, but then was narrowed considerably due to influence and pressure by the U.S. And so I'm wondering if, in assuming that the U.S. has potential to be prosecuted, you're also assuming that it no longer possesses the necessary political influence to limit these statutes going forward.
Yeah. Why don't you answer that straight out?
Yeah, no, obviously, the U.S. actually has more potential to pressure national courts than an international court, and basically threatened to move NATO's headquarters out of Belgium if they didn't pair in the universal jurisdiction statute, and it was successful. I will say, on the other hand, that there are a lot of countries, Spain, other countries, that have very aggressively looked at the acts of torture and have opened criminal investigations into John Yoo and the other, drafters of the torture memos. And whether those cases go forward or not, it has a chilling effect. And that's really what I was thinking about here, is that there's the possibility in some countries, cases are not brought by a prosecutor, but by individual complainants, and that's the way it was in Belgium. There's several countries like that, and if that's the case, you may see complaints kind of winding their way up before the U.S. is able to pressure the government to do whatever it needs to do, and that itself is going to have a chilling effect.
Thank you. Matt?
You both seem to have analyzed this issue or thought about it at least and concluded that immunity ratio materiae as the House of Lords first release wouldn't bar prosecutions under universal jurisdiction of state officials for aggression. And I was wondering how you came to that conclusion, given how much the House of Lords had to struggle to find that torture not go ratio materiae how firmly fixed against torture is in international law in comparison to perhaps aggression.
Who'd like to take that?
I mean, I'm happy to.
Yeah. Oh. Well, they're both international crimes. So I think, well, one issue is, of course, whether the particular conduct was in the course of that person's duties while in office. Now, that was clear, I think, from the Pinochet case, though one of the law lords, I can't remember which one, in the first round, I think, held that it was actually not an official conduct, since conduct of that nature cannot be official. But I think that well, torture is criminalized in a convention, which makes it slightly easier to determine, but legally speaking, it doesn't really matter whether it's criminalized in customary law or in a treaty.
I mean, I would add the ICJ decision in the Euridia case, which is the Belgium arrest warrant case, only applied to sitting heads of state and sitting foreign ministers, because under a legal fiction that the ICJ takes a case as it was at the day it was filed, even though Euridia was no longer a sitting head of state. And so all the dicta in there that seem to indicate that the ICJ thinks that if you commit crimes against humanity, that's still protected by head of state immunity, that only applies for sitting heads of state. So then that leaves you basically with Pinochet, the Marcos case, the Noriega case, all of which in Pinochet 1, they spoke a lot about crimes against humanity and said, look, those are Jus Kogan's crimes. There should not be head of state immunity for a former head of state that has committed those. And I think that analysis would apply even more to the crime of aggression. In the final Pinochet case, you had all these mixed decisions, and ultimately it was a much narrower decision. It was sort of a waiver by treaty kind of decision. But I think that the first Pinochet case, even though it's not good law in the UK, is still some persuasive authority that other countries might look at.
Who's up? Georgia.
I'm curious that significant political capital and mileage consideration was given in the lead up to the Kampala conference regarding conditions for the exercise of jurisdiction. And as the earlier panel set out, that there are so many additional safeguards.
Okay, to weigh in on this, because we have an expert in the room, Astrid, who's done a study of, I think, a number of jurisdictions that have already incorporated the crime of aggression and domestic criminal law. Maybe you have some insight about how it's gone with them, and if you think in the future the jurisdictional regime might also be incorporated into domestic criminal law.
Yes. There is, as far as I remember, I found some 25 countries that have implemented the crime of aggression into the national legal statutes, and I'm not talking about countries, certain common law countries that might have a monistic system and would be able to just apply the customary law of aggression. So I only looked into statutory laws. So there's a number of them. They all are from a time before the adoption of the Rome Statute, so they mainly reflect the Nuremberg precedents. They mainly have the definition that you can find in the Nuremberg Charter, being a crime under national law as well. The only exception or relevant exception is Croatia, which has a definition that was taken kind of in the middle of the way of the negotiations up to the Kampala conference. And they already have implemented explicitly the parts of Resolution 3314 as a basis for the crime. But there are other commentaries that would also accept the term war of aggression as used in Nuremberg to extend to acts of aggression as being defined by Resolution 3314. There's a very different, diverse jurisdictional basis for these national statutes, and I have found only very few examples, although I remember 3 or 4, where you actually find universal jurisdiction for the crime of aggression. The rest of the countries have a very mixed jurisdictional basis. I never saw the necessity to implement jurisdictional procedures with respect to any crime on international law into the domestic legal system. So I would only see the definition of the crime of aggression to be an example to be taken on the domestic level. Also with regard to complementarity, that you are not much more narrow than the international definition, and the ICC in a case might say that you are unable or unwilling to prosecute properly because your definition is too narrow and there's a margin that is not covered. So I don't really see states, particularly those that were very strong in a broad jurisdictional basis, even for the ICC, to now come and reduce the national jurisdictional basis by, for instance, introducing a Security Council resolution, determination, prior determination in the domestic codes. I would not really see that.
Thanks a lot, Astrid. Anyone else? Yes.
It's been mentioned several times today, the shift of defining aggression as either a just war or an unjust war, to instead defining it as a manifest violation of the UN Charter. And I'm curious if you think that that could potentially undermine the idea of complementarity, because I don't see how any state in reality could practically prosecute its own officials for waging a war that's viewed nationally as a just war, even though some other independent body might consider it to be a manifest violation of the UN Charter. I'm just curious how that conflict is resolved.
Who wants to try that? Don,
I
please,
think
yeah.
there's a point that was made earlier, and I know that Astrid quotes it in one of her articles as well, having to do with the International Law Commission's comment back in 1995, which I'm going to read, quote, for short, that the crime of aggression was inherently unsuitable for trial by national courts and should instead be dealt with only by an international court. I think it really goes to the heart of the point that you're trying to make, that this was their really supposition at the time.
Can I add that?
I'm not saying they're correct, but
Todd had his hand up for a while, so I'll just go down.
It said that, but it said, and I think one of the panelists referred to it as the ILC's sort of evaluation of what was good policy and practical, but the quote I have here in my book, which who knows where it's from, but it's from it says it's from the ILC. What the actual quote is, it's the exercise which entails the exercise of jurisdiction by the National Court of a State, which entails consideration of the commission of aggression by another state would have serious implications for international relations.
Did you slow down?
Yeah, that's the policy
Faster, please.
part of it.
Yeah, faster.
But the sentence before it is the determination by a national court of one state of the question of whether another state had committed aggression would be contrary to the fundamental principle of international law. So it makes a clear legal conclusion.
Yeah.
And I agree. It's it's not 190 days, but it is the ILC. And I think there is. I mean, Michael was very good and persuasive presentation, but there's a whole other strand to this, which I think actually is a better predictor of what actually happens in the world. And actually, the question I had maybe for Astrid, if I could, is what practice have you found in what's actually prosecuted? Because I see this as a very destabilizing phenomenon. I imagine, Georgia and Russia, and you find that case prosecuted in a Georgian court, you know exactly how it comes out. You have prosecuted in a Russian court, you know exactly how it comes out, and what's really benefited by that. You have the NATO intervention in Belgrade that's prosecuted, Secretary Blunt goes to it's prosecuted in Belgrade, it's prosecuted in Moscow. I mean, they called it aggression. I mean, what is it that would really be unleashing here? And I actually find that the members of the international community will hopefully act as the extreme ones with much more restraint. And can I mention one other thing also? Sorry. And I think that was one of the reasons why there was actually it seemed to me, very little opposition to getting that understanding in the way to annex 3.
Who's up now?
Can I just respond to that question
Yes,
too? Because
please.
I think it's a really important one.
Yeah.
I want to respond to your question. Huh? Yeah. All right. So, from the perspectives of semiotics, which is the study of the way that words change over time depending on their interpretive communities, I think in the 65 years since the UN Charter has been adopted, that the concept of just war has evolved, and that today most people in the world think of an unjust war as synonymous with a war that violates the UN Charter. In other words, it's not authorized by the Security Council and it's not in self-defense. And so it is possible that those two things are no longer different, that the meaning of just war and the meaning of manifest violation of the UN Charter in today's world are interpreted similarly.
Okay. From the audience. I would like to call on the commentators if you had anything to say on this.
No. I'll wait.
Oh, sorry, Paul. Okay, let's start with Jennifer, and then we'll go to Paul.
Just a few different thoughts. One, I guess, to Todd, the understanding that was readily agreed to, but can an understanding tell national courts what is or isn't customary international law? I think it's got some limitations, and maybe we can talk about that aspect. I don't know, I agree with Paul's comments. I don't know how prevalent this use will suddenly become because we have limitations. Is more likely a domestic court will say this is a political question, there are procedural immunities, active state. They may not have the person in custody, they may not have the national security information that would be required to evaluate, did this person engage in planning, preparation, initiation, execution of an act of aggression. But I think our much bigger question, which is a great question to be talking about, and maybe we should have talked about it a lot earlier, is this a good thing? I do see act of aggression, crime of aggression is somewhat different, again, from other crimes. And there is something to, can a state sit in judgment on a neighboring state? And is that sound? And George's comment as well. So we've created filters at the international tribunal level, but I think we haven't created anything at the domestic level. So, we have pre-trial division filters and Security Council filter that we, put in place for international purposes, but we just have a definition for domestic purposes. And I don't know if authorization by the executive cures this kind of issue, because I do share some of the concerns I'm hearing in the room. We're not talking, complementarity is not about any trial, it's about fair trials, right? Impartial trials. And just by the nature of it, isn't it going to be very hard for this to happen. First, I don't think doing fair and impartial trials of these crimes is so easy in any cases. I think adjudicating genocide, war crimes, crimes against humanity are tremendously difficult, complicated crimes, complex proof. Judiciaries are often incapable of adjudicating these crimes and need a lot of help. And I don't know we're paying sufficient attention to this issue. You know, if we do eventually have a few Darfur cases from the ICC and a few DRC cases, and then we look at the magnitude of the crimes, what is left over? Oh, gee, it's the vast bulk of the crimes. And who's going to deal with these? Oh, it's the domestic judiciary. Well, what state are they in? Are they really going to deal with these crimes in a fair, impartial manner? Well, I think aggression is potentially even more dicey because, yes, I do see some element to, won't it just be inherently so natural for, if you're looking into your own state's act of aggression, to tend to whitewash it. And I'm not saying all states would. Maybe there's been a complete change of regime and they're seriously going to look at it. Or maybe it's not. And will we be able, so easily able to tell the difference for Article 17 purposes? So, you know, not a clear sham trial, but won't there be a real inherent tendency to go easy on your national leaders unless there's been a complete change of regime? And similarly, if a perpetrator apprehends the leader of a neighboring country, won't it be so much the tendency for those perpetrators' courts to go hard on that leader? And again, will we always know this? You know, obviously, when a tribunal is, you know, very clearly unwilling or unable is a very easy case. But what if they go forward and, you know, we are not quite sure what is a sham, and it looks like they're applying ICCPR Article 14, which we would hope doesn't always happen. But yet, isn't it fraught with much more peril than the other crimes?
Thank you. I'll call on Paul to give a closing remark, and then I'm going to call the panel early so that we have time for Stefan to finish off the conference and for him to make his flight.
Oh. Okay, thank you, Noah. I have three brief comments. The first one concerns the prospects of countries legislating on the crime of aggression. Well, I think that for many countries it's a natural part of the routine. If they ratify a new provision, they examine whether this needs or whether it justifies new legislation. So I think it will come on the agenda much more than it has been. So even if there are now just a fairly small number of provisions, most of which refer to Nuremberg one way or the other, I think that situation will change within the next few years. Regarding the prosecutions of one's own, I would think that there is kind of a vague duty to suppress the crime of aggression, sort of enveloped in the general duty to suppress international crimes, but I don't know how specific that is. Now, the third comment, and that's Todd's extremely important question, is this, will this be useful? Well, first I should say that I did refer to the ILC commentary's reference to that international law principle, that principle is the principle that one state cannot sit in judgment over another state, and I think that's a very vague principle. You cannot really derive any specific norms from that principle unless you have an amount of goodwill. And I actually went to the records to check who said what, and it was a few years ago, so I don't remember exactly who said what, but I have a strong memory that the French delegate, who I think was Alain Pelé at the time, was a strong proponent of a very, very limited scope of jurisdiction for domestic legal systems. But nevertheless, prosecutions of aggression will be not only difficult but also potentially dangerous. So I fully see this. Whether the on balance, it will be more good or more bad. That's very difficult to say. But I think generally it would be preferable to have to have cases before the ICC rather than in domestic jurisdiction. So I would, I don't necessarily think that the principle of complementarity works well for this particular crime. I don't think that aggression is by nature hugely different from other crimes, but there is a difference of quantity rather than of quality. It's typically more dangerous than the other crimes, which do not necessarily mean that other crimes are politically innocent. Yeah, I think one cannot really say anything with any more certainty about this issue. Thanks.
Just a very, very short follow-on to the question of whether this is all useful, having these laws on aggression, having the definition. I just want to draw people's attention to what's going on in the UK, where I reside now, with respect to the Chilcot inquiry. It's fairly well known today that when the British went to war in Iraq, their top generals said they didn't want to be sitting in the dock next to Milosevic, so they wanted an attorney general's legal opinion, which was effectively squeezed until Tony Blair got what he wanted it to say. And that's, all, of course, all coming to light now. But I just want to say that in terms of the court of public opinion and the apprehension on the part of people who are at the decision level, making level, that the fact that at least they have a question mark in their mind about who will be looking and what scrutiny will it be under is, I think, a very helpful thing.
Yeah, okay, thanks. That's a good note to end on. Help me to thank our panelists for this great panel. Thanks so much for coming.
I'd like to thank our panelists again, and at this time ask our panelists if they could please take a seat. At this point, I'd also like to invite everybody who's with us. First of all, I'd like to thank you for staying with us throughout the entire conference, and would like to invite everybody here. We will be hosting a small reception, a cocktail hour at Six Plates Restaurant. Just down the street on Irwin Road. We invite everybody to join us over there. Just a quick note to our participants staying with us from out of town and who came over with us. Please see Chris and I about whether you'd like to stop by or go back to the hotel, or whether you'd like to come with us directly to Six Plates after the conference. And I'd also finally like to introduce Chris again to come up and introduce our closing speaker, Stefan Berisha.
All right, well, thank you again to all of our panelists, moderators, commentators, and audience members. This has been a truly interesting and provocative conference, and I'm very glad you could all be here with us today. And to close the Road from Kampala conference, and to leave us with some final thoughts on the ICC and the crime of aggression, I would like to introduce once again Mr. Stefan Berisha. We heard him speak earlier on the panel regarding the exercise of jurisdiction. And as we all know, Mr. Berisha is a key player in the international criminal law community. And to borrow the words of Dr. Kress, Mr. Berisha is the mastermind behind the Kampala conference. Please join me in welcoming once again Mr. Berisha.
Thank you very much again for that very kind introduction. I hope I don't have any criminal responsibility for what happened at the Kampala conference. So nevertheless, thank you for that, and thank you for that particular challenge to give a closing address. I'll try to do it to some of the blur of my condition at the moment. And I also would like to interpret my mandate closing address as a free-for-all, that I can comment on any issue that came up in the course of today, and that I can comment on other panels on which I was not sitting. So that's really a great opportunity. But more seriously, I'll try, and it's going to be not very easy, because it has been a very rich discussion, to somewhat maybe, again, put everything together, in particular for the benefit of the students that came here on a Saturday morning and afternoon, and I applaud you for that. I think what our discussion on substance today has shown that Kampala was actually not just about Kampala, but this was a step in a process that relates to issues that started in San Francisco about how aggression was added to the UN Charter, went through the Nuremberg trials, and the first time in international law that actually the crime of aggression was adjudicated at the international level. Going to Rome, where states parties took the decision in principle that aggression should be under the jurisdiction of the court, but left it to the future and left it to the review conference in Kampala to decide on a definition and on the conditions for the exercise of jurisdiction. And so then in Kampala, we were there with this, what was really an absolutely unique opportunity to close that circle. My ambassador certainly, prior to Kampala, was always of the view, while the odds are somewhat against us, that we will actually find a consensual agreement on all the issue. After Kampala, it would have become only much more difficult, that it was a unique moment of political momentum to actually get this done. And I think that all delegations actually realized that there was a unique moment to come together on hugely important but also hugely difficult and controversial issues. And this is what allowed them to go to the negotiation table with certain spirit of flexibility and compromise that allowed us to adopt the package by consensus in the end. So I think we spent a lot of time talking about what's in that package, so I want to briefly go through that again. I think that overall, the general gist of what we heard was that while, of course, it was a historic breakthrough on the principle of defining aggression, nevertheless, it was done in a quite cautious way by agreeing on a package that on substance is rather restrictive when it comes to the definition of the crime, and also rather restrictive when it comes to the exercise of jurisdiction. So let's go through some of the elements. We had one technical challenge, which was to define the individual act of aggression, what the individual does, and we had the great fortune that we were not doing this in a vacuum, but we had already the Rome Statute, and we managed to integrate the definition of the individual act into the Rome Statute in a relatively smooth manner. We had the fortune that there was a very solid understanding that the crime of aggression is a leadership crime, and we did so as part of the definition, which I think personally would have the effect that also any domestic implementation of the crime of aggression would also be based on the leadership principle. We had, of course, a lot of difficult discussion about what the state act of aggression is, and I think a very interesting process whereby we were using, on the one hand, General Assembly Resolution 3314 of 1974, which is a political document, not really a document that was meant to be a guidance for courts, but it was a document that had a very, very strong political support, and this strong political support we could not overlook. So we combined this document with a very strong threshold clause, which should ensure that actually, in the end, when you look at these two things together, first of all, you do have the principle of legality respected, and you also, from a policy perspective, have ensured that really only the most serious and only the clear cases of aggression are cases for the International Criminal Court. This, of course, does not affect all the other law on state responsibility that is out there. It does not affect such issues of just war, of self-defense, etc. I should maybe add a point here, because I'm not sure if it has been mentioned previously. One of the criticisms of the definition, in particular one that Michael Glennon has put forward, was that it was said that it seems to be that even cases of clear self-defense could be seen as aggression under the definition of the State Act. And I would like to emphasize here that certainly from the drafters' perspective, that was certainly not what the drafters thought. In the second paragraph of 8 bis, you will see the phrase inconsistent with the charter. Some were not sure whether this refers to all types of acts of aggression, that all types of acts of aggression would have to fulfill that requirement of being inconsistent with the UN Charter. But I invite you to afterwards look at the elements of the crime. I think it's the 5th or the 6th element that requires that the perpetrator must be aware of the factual circumstances that establish that the use of force was inconsistent with the UN Charter. So from my perspective, there is actually no argument to say that this definition in principle would even allow an argument that a case of self-defense or a case of authorization by the council could be aggression, which would of course be absurd because that would be in such direct contradiction with the UN Charter to say that. And again, in the elements, we try to once again reconfirm that. I think we've heard some very interesting elaborations today about humanitarian intervention and other gray areas of state responsibility and of the use of force. And here, I think, indeed, what we did in Kampala was to say that that the ICC is actually not the right place to make progress on these extremely divisive issues. As was rightly mentioned, humanitarian intervention was certainly the big elephant in the room. And had we focused much more on spelling this issue out explicitly, of course, the whole negotiation process would have run into a real train wreck. So on this issue, I think what was mentioned about that what we did was to restrict the definition to the most serious and clear cases. That is probably the answer to those questions. And the understanding certainly also stressed that as well. When it comes to the role of the Security Council, I think that's also an extremely interesting and exciting part of this discussion that needs to be looked at several levels, because the role of the Security Council is not a one-dimensional issue. The Security Council actually comes up several times in the context of the Rome Statute, and more specifically in the context of the crime of aggression. There is a purely procedural role, in particular for the Security Council, that was there before, namely that the Security Council can make a referral, which then leads the court to take up the issue of the crime of aggression. This is Article 15 ter. So the Security Council, as was confirmed in Kampala, should have this role also with respect to the crime of aggression. And that is actually, I think, on substance an extremely important role, because that's the only way in which a case can go forward regarding a crime of aggression that involves a non-state party. So the Security Council is the one organ that basically delegates the jurisdiction to the ICC if a non-state party is concerned. On this issue, I should add also that the Security Council does not have to specify that it's a case of aggression. So this is something where the Security Council can basically pass the ball to the ICC. The Council does not have to make that determination of aggression in that context. Another procedural role for the Security Council that also was there before, again, is Article 16. The Security Council can always use the tool of Article 16 to suspend the investigation for 1 year. More difficult, of course, were our discussions and negotiations on the question what happens when the Security Council does not take the initiative to refer the case to the International Criminal Court. And here, I must say, we have made, and states parties in Kampala have made absolutely massive compromises because in the end, they agreed to a consent-based system. When the Security Council is not helping and the pre-trial division filter is kicking in, this can only happen under this consent-based track of 15 bis, which excludes non-states parties and which allows states parties to opt out of that track. There is actually also a substantive role for the Security Council regarding a determination of aggression. Everything I've said so far was procedural, but there's a substantive role, namely, again, in 15 bis, when the prosecutor is starting his case and thinks he has a reasonable basis to go forward. sends the letter to the Security Council with the information. If at that point the Security Council makes a substantive determination of aggression, that is a sufficient condition then for the case to proceed, and there is no reason for the prosecutor to involve the pre-trial division on that question. So there is indeed a substantive role also regarding a determination of aggression. At the same time, very importantly, this determination of aggression, if it occurs in such a case, would not be binding on the International Criminal Court. We have a very clear provision in there that safeguards the due process rights of the accused, and therefore the ICC, and in particular the prosecutor, would have to prove beyond reasonable doubt that all the elements of the crime are there, and that includes the state act of aggression. So I would say in sum, regarding the role of the Security Council, we actually did not do that much to the role of the Security Council that was not there before. And indeed, it's a constitutional issue. How could the ICC and how could the Rome Statute confer any powers to the Council or take away any powers from the Council? But in the end, what we did to deal with this tension was that we decided not so much to tackle the role of the Council, but we decided that the court's role, the scope of jurisdiction of the court, would be reduced in those situations where the Security Council is not the one that actively takes the case forward. We had a long and complex panel on the issue of the entry into force and conditions for the exercise of jurisdiction. And one thing that I forgot to mention then, so again, I'm grateful to have the opportunity now. One reason why this is so complex and complicated is, and I say it because I was not in Rome, it is because of the mess that was left behind in Rome on this issue. While, of course, the Rome Statute says aggression is under the jurisdiction of the court, it does not say clearly how we would be completing the definition and how we would be completing the conditions for the exercise of jurisdiction. Most specifically, the Rome Statute did not say it's 121.5. It just said 121 and 123, and it stopped there, and it was not more specific. And in fact, this whole package of Rome about how to transfer this discussion to the next level was, of course, a last-minute compromise for which there is very limited travaux and very limited insight on what all these provisions actually mean. And as we found out, all of these provisions that deal with aggression and the way forward on aggression in the Rome Statute are actually difficult to reconcile. They seem to be saying different things. And so I think it was very important that then in Kampala, we attempted, and I think we were successful in doing so, we attempted to reconcile them by consensus. That we looked at these provisions and came up with a package that was adopted without a vote. Let me maybe also say on these entry into force procedures, while they were problematic and difficult to deal with, that in itself also gave some room for delegations to come up with creative ideas. This is one reason why there was the ABS proposal and why there was the Canadian proposal and others. Because it was so difficult to deal with, it allowed delegations to leave their national positions aside for a moment and try something. And this process of trying to bring up new ideas, I think, was absolutely instrumental in us making progress there. Very interesting, I think, the discussion on complementarity and the impact of the adoption of the amendments on aggression on domestic jurisdictions. On this issue, I think the review conference was a little bit uncomfortable because this was one of the topics that we had not discussed in great depth in the years before. And it's one of the issues where I would have wished the U.S. delegation would have come earlier to our negotiations, because I think it is an enormously important topic, and one that would have required even more in-depth consideration by states parties, and I think it could have been done in a very constructive way. And I think in the end, states parties did just that. In Kampala, they dealt with it in a constructive way by stressing in the understandings that what we were doing in Kampala was meant just for the purpose of the Rome Statute, and that one should not necessarily draw conclusions just from what we did in Kampala, conclusions for domestic jurisdiction over the crime of aggression. Because indeed, I think there are some discussions that need to be had, and we heard some quite differing views today about, in particular, the application of universal jurisdiction over the crime of aggression. I must admit that going into Kampala, I thought that one thing was realistic and possible, namely that we would be able to adopt at least a definition. And had we done that only, I think in that case, one of the benefits of that would have been that indeed states would have taken that definition and would have updated their domestic criminal codes. It is, I think, interesting to note that only about 25 or so countries currently have the crime of aggression on their books domestically. And I think for many of the other states, an important reason why they don't have it is because there was an ongoing debate at the international level how to define the crime of aggression for the purpose of a criminal code. So I do think that many countries will now, after looking at the outcome of Kampala, go ahead with that. But I think we need to continue some discussions about to what extent that should involve prosecution that also deals with other states, because indeed there are good arguments to say that domestic prosecution of other states can be dangerous in the context of aggression, in particular in cases where there is a pretty obvious self-interest involved. When it comes to the issue of what I think Jennifer named it sham trials at the national level over aggression. In this respect, I must say, I don't see aggression very different from the other core crimes. There can be pretty much the same situation, that you could have a trial at the domestic level over war crimes just for the purpose of ensuring that the case does not go forward at the ICC. And that leads me back to our very early discussion of the issue. When we discussed this issue in the context of the Princeton process, several years prior to Kampala, we were mostly focused on this aspect. We said, well, is there anything different regarding aggression when it comes to the question for the prosecutor looking at the domestic jurisdiction and having to check whether a state is genuinely willing and able to prosecute? From that perspective, it's not so special, and we did at that time not look very much into other related questions. One question that kind of puts everything together, I think that was raised also several times, was it useful, what we did in Kampala, and what's the purpose as we go ahead? What will be its impact, and once it will be activated? I think this question should be answered looking at the domestic level separately from the international level. I think at the domestic level, I would say that it will. That would be my personal prediction, encourage a good number of states to actually increase the scrutiny in this regard and the criminalization of of acts of aggression at the domestic level, and thereby add an additional rule of law layer on the use of force at the domestic level with respect to their own executive. As far as the international level is concerned, I think it's quite early, and it's would be quite difficult to speculate what the impact really would be. I think we are, in this regard, somewhat at an even earlier stage than what was mentioned before, when the ICTY and the ICTR, these international tribunals, began to adjudicate a body of law that was not well adjudicated before. Because in this context, we have yet to even activate the jurisdiction over the crime of aggression. And of course, due to the very restricted substantive definition and the rather restrictive jurisdictional regime, I think it is fair to say that one cannot expect lots of cases to go ahead at the ICC by any means. But I also think that at a more structural level, if you think about, again, aggression as the supreme crime that was adjudicated in Nuremberg after World War II, somewhat it just remained a huge gap in international law, that the one single worst crime that is out there was neither defined, nor was there, at least in theory, any permanent institution that could actually adjudicate this crime. I think that simply in terms of the structure of the international system, having filled that hole is in itself a great value that then can only be complemented by what I hope will be useful and appropriate, fair and genuine trials in cases where it has to happen. Of course, my real hope would be that it would never, ever be necessary. Thank you.
On behalf of the ICCSN, I'd like to thank again Mr. Stefan Barriga for his wonderful closing comments, which I think highlighted some of the fascinating topics that came up for discussion today. I'd like to thank again our donors for their generous contributions, without which this would not be a reality. I'd like to thank our panelists, moderators, and commentators for creating such a stimulating discussion, and I think really informing all of us about both the court and the crime of aggression. And finally, I'd like to thank everyone here for participating in this conference, and I encourage you once again to join us at Six Plates, and I encourage you to join us at future ICCSN events next semester and beyond. Thank you, everybody.